My greetings to all the participants and the panelists joining us from India, the Dominican Republic, and other parts of the world. I, Pratichi Avinash, Manager Marketing at R&M India, welcome you all to today's webinar on doing business between India and the Dominican Republic. In the next 60 minutes, we'll delve into the nuances of business interactions, cultural considerations, and key insights that can pave the way for successful collaborations between India and the Dominican Republic. Feel free to actively participate by asking questions in the Q&A box below. Your curiosity and engagement are vital to making this session truly enriching for everyone. I would now like to hand over to Mr. UN Marva, Chairman R&M India, for the welcome address.
Good evening, all of you in India, and good morning to those in Dominican Republic. A very warm and welcome to all of you joining us today for the webinar on doing business between India and the Dominican Republic, which is organized by R&M India. We are thrilled to have such a diverse and engaged group of individuals gathered here today to explore the opportunities that lie at the intersection of these two vibrant nations. R&M India is a consulting firm operating in Delhi for 77 years across 3 generations, having branch offices in Gurugram, Bangalore, Mumbai, Raipur, and London. The landscape of business between India and the Dominican Republic is evolving, presenting a myriad of opportunities for ventures and collaborations. Both India and the Dominican Republic are experiencing a tech renaissance, with India's prowess in IT and the Dominican Republic's growing tech sector. Increased collaboration in areas like software development, digital innovation, and perhaps even fintech ventures is expected. Understanding the local culture is key to successful business ventures. With the rich cultural diversity of both nations, we anticipate a surge in initiatives promoting cultural exchange, fostering better understanding, and creating more seamless business interactions. The business landscape between India and the Dominican Republic is dynamic, promising exciting ventures that go beyond borders. Before starting this session, I would like to introduce and convey my gratitude to all the panelists who have joined us to share their experience and expertise. Welcome Alberto Rice. He's a partner of Guzman Ariza, Dominican Republic, an expert on matters of public procurement and an expert witness of the Dominican Republic law and practice for several cases in the USA and other jurisdictions. He assists construction companies with their real estate development using the trust structures of the Law 18911 of the Dominican Republic and assists various arbitration procedures, serving as an arbiter and attorney for the parties. Alberto has worked as an external advisor for the Ministry of Commerce of the Dominican Republic in negotiating and formalizing the Dominican Republic Central America FTA with the US government. He assists major developers with branding, financing, and construction of the residential projects, hotels, and resorts in the Dominican Republic. Sumit Singh, or we have Pamela Benzan, is a partner as Guzman Ariza, Dominican Republic. Pamela is an expert assistant to the consigliere in 2 of the most complex and important commercial restructuring cases in the Dominican Republic. She represents entrepreneurs, startups, private equity companies, and joint ventures in a wide variety of industries. Pamela advises international and local clients in their commercial and investment matters in the Dominican Republic. She counsels in most of the restructuring and insolvency cases currently in the Dominican courts. Her practice focus is on advising local and international clients in private mergers and acquisitions. Her experience includes advising clients in corporate and financing transactions, including documentation in different industries. Pamela is one of the most sought-after lawyers as a speaker for seminars, events, and meetings. Welcome, Pamela. Sumit Singh is Direct Tax R&M India, has 20 years of experience in the direct taxation domain. He represents before the Income Tax Appellate Tribunal, Dispute Resolution Panel, and the Appellate Commissioners of Income Tax for domestic and international tax issues. He has a wide experience in evaluating and providing advisory opinion on double taxation and caters to merger and acquisition strategies for overseas companies. Jagrati is a partner at R&M India and heads the transaction and regulatory advisory services based in Mumbai. She has 25 years of experience having worked for large business houses, catering to various sectors such as healthcare and pharma, sugar, infrastructure, real estate, financial markets, chemicals, dairy products, etc. She has significant experience in structuring and implementing transactions. Jagrati specializes in corporate restructuring, mergers, amalgamations, demergers, capital restructuring, valuations, due diligence in all equity transactions and acquisitions, IPO, corporate law, and exchange control regulations, matters relating to BIFR, post restructuring of SIP companies. Lastly, I would like to introduce our moderator for today's session, Raghu Marwa, Managing Partner and CEO of R&M India. Upon qualifying and becoming a chartered accountant, he joined the R&M team after gaining experience at the Big Four. He comes with an experience of more than 20 years and specializes in advising and structuring businesses abroad for Indian corporates, building India entry strategies for foreign clients, cross-border holdings, M&As, and valuations. He oversees the consultancy services and the international taxation in the firm. Now, get ready for an enlightening session that may well be the catalyst for your next business venture. We look forward to all of you, your interaction, and welcome aboard, and thank you for being a part of this exciting webinar. I would now like to hand over to Raghu for opening session.
Thank you so much, Mr. Marwa, for your kind words and the introduction for all the panelists. And hello again to everybody from India and Dominican Republic. We have a very exciting session before us. And I'd like to begin by firstly quoting from my favorite actor, Dwayne Johnson, who had once said that success isn't always about greatness. It's about consistency. Consistent hard work gains success, and greatness will come. I think that is a very strong message for all of us, that, you know, to remain consistent in our effort, whether it is, you know, doing business in India or Dominican Republic, or helping our clients with trade and avoiding litigations. And with that, I'm going to start straight away with our first topic, which is doing business in Dominican Republic, by asking Alberto to share his views on the trends, practices, and the ease of doing business in Dominican Republic. Over to you, Alberto.
Thank you, Raghu, and thanks to everybody. It's very We're very pleased to be here sharing with you about doing business in the Dominican Republic. Well, the Dominican Republic is an island in the Caribbean that is have been developing in a very fast pace for the last 2 decades, mostly. And we are because of the what we have opening our frontiers to the foreign investments and the development of many, maybe all industries in the DR. So we do the service industry, manufacturing, and since we are strategically placed in the Caribbean, we do a lot of exports and take advantage of that position to be kind of a hub for Latin America and Central America. And in that way, we have also been shifting our legal frame to embrace the opportunities that our geography give us. So what we do, the Dominican Republic is a civil law country. Like our system relates from the French codes of Napoleon Bonaparte that were brought to the Dominican Republic in the 18th century. So we have done, of course, amendments to those, but we are a very related to the French law. So mostly in civil and commercial, and then we have adapted our system to other jurisdictions, following up the practices of these countries that speak Spanish, like the ones in South America and Spain. In which concerns business between India and the Dominican Republic, India and the Dominican Republic establish formal relations by having diplomatic agendas since 1999, and we have an embassy in New Delhi, and India have an embassy in the Dominican Republic, and we've been even signing agreements and memorandum between the countries for cooperation. One of them have been mostly to the development of technology, and the one most used have been for the development of technology as well. In our trading, we do exports to India, and we do imports from India. Most of them come from garment and textiles and pharma. Also equipment and lease of equipment even it has been recorded in our custom databases as an interchange between both countries. The average of the trade is roughly $1 billion between both countries. So we export to India about 500 millions, and we import kind of the same amount every year since the last data published by our government. In the trends, what we're doing now, we have a few bilateral trade agreements. One of them, and the most important one, maybe is the DR CAFTA, is the agreement between the United States, Central America, and the Dominican Republic for free trade. And because of the DR CAFTA, we developed a legal frame to establish logistics centers for nearshoring, trying to bring in investment from Asia and Europe to the Dominican Republic. So you have the country as a hub for maybe labeling, ticketing, repacking, and then shipping the conglomerates that you bring to the Dominican Republic to different countries, and then saving some money on logistics. And in those logistics centers that we have created, they are free of taxes. You don't pay taxes even for the import or for the export, and you don't pay income tax either. It's just the fees for the operations on the ports. That's one of the trends that the Dominican Republic is working on to bring in investment. The other trends we have is the free zones. The Dominican Republic have two types of free zones: the industrial free zone of the law 8 of 1990, sorry, and then you can establish yourself in a free zone park, and then you will be exempt of taxes for everything you do and sell in the Dominican Republic. You don't have to pay taxes to import the goods to manufacture. You don't have to pay taxes for export. You don't pay income tax. The only tax that you may pay as a free zone is if you distribute dividends as a company to the shareholders, then you will withhold 10% of those dividends, but not the company itself. Is full exempt of taxes. We also have a law for textiles. It's a special law for free zones for textiles. So you can manufacture and ship outside the Dominican Republic shoes and garments. And that law also grants you the same benefits of a free zone, but it's a special law. So it's different from the free zone trade law, but it's also kind of the same legal establishment that you are also exempt to create this kind of garments and export them into any country, or you can't even sell it in the Dominican Republic. It won't be any problem at all. Also, we have on pharma side, the government have a very big program that is called Promise, like a promise, that is to help the low income classes access to medicine. So we do a lot of sales of generic pharma, and one of the main providers is India, actually. So there you can bring in also a lot of business opportunities, and this one is run by government. You'll be selling to the government, and then the people will access to those. But also you have that on the private sector. You can also create pharma. You can also work on private sector and sell medicine to the hospitals or the particulars in the pharmacies. There is a lot of things going on that side in the Dominican Republic. There is a growing population that is more aware now that you need to take care of yourself. So not only for medicine to cure disease, but also to prevent, like having a lot of custom-made vitamins and minerals that the human being needs to support his health system. One of also the trends of the Dominican Republic is our system of residencies and having the nationality of the Dominican Republic. For that, I will pass the word to Pamela Benson. She will share with you a little bit about that and how we use these programs in the Dominican Republic.
Thank you so much for that, Alberto. Pamela, can I just add, in addition to the investor visa program that Alberto said you're going to talk about, can you also share some light about, the political stability, as well as a little more about the foreign exchange, how stable the foreign exchange rate is, and if it's pegged to the dollar, or is it, freely convertible and moving? So if you can just talk about these three things, that'll be great. Over to you, Pamela.
Okay, thank you very much for inviting us and having us here. In relation to political stability, as you may have noticed in different legal guides and other statistics that have been shown comparing Latin American countries' growth, we are actually the second most growing economy in Latin America, and actually compared to the whole South American, Central American as well. We are there along with Panama in the most growing economy in Latin America. We have a very stable legal frame that it's made basically to accommodate the needs and also for the foreigners to take advantages of our legal system. There are no disparities in the law except for very regulated sectors, such as telecommunications, energy sector, and insurance, that is the same in many other countries. But except for those very specific sectors, foreigners are very welcome to invest in the Dominican Republic. There are no distinctions between the rights and duties between foreigners and Dominican citizens, which is something that actually is a very good advantage in regards to other countries that do require that you have, for example, a Dominican to be able to incorporate a Dominican corporation. That is not the case here in Dominican Republic. Also, if you want to buy land, real estate, acquire a property, invest in a business, you do not need a Dominican citizenship or residency even to do that. So our political framework right now, it's also very stable. We have a government that has been making a lot of progress to fight corruption and stabilize things in all the ministries. We have a very stable legal framework as well that has been in place, and it's also a very accommodating to the international standards, and it's always trying to adapt to international programs and international guidelines. So we are up to date in everything in relation, for example, to intellectual property, insolvency law, environmental matters, energy law, and we are always issuing, or the government is always issuing new norms and new laws that can accommodate to all these globalization issues that have arisen in the upcoming years, especially because of the technology. We are in the government, they are making a lot of initiatives to try to use technology to provide a better service to the citizens, to the investors, and digitalize all the programs and all the procedures in the Dominican Republic, for example, for trademark registrations, even for obtaining permits in the Ministry of Environment. They have made programs available that you can actually seek or apply online, and that it's something that has helped us to expedite procedures that a few years ago used to take a lot of months or even years, and now they are more expedite. Also in relation, for example, to arbitration, we have a very good law that recognizes arbitration rulings that have been issued abroad, so that you can execute them here and obtain a payment or execution of guarantees. So we have legislation that is very protective of the international investment, and it also offers a lot of advantages, so that the international or foreign investors feel that they are going to make a good investment and that they are going to make profit in the Dominican Republic. Something that distinguishes us also from many other Latin American countries is that we have an excellent location, and that is why we have so many logistic centers, because we are called the hub of the Americas, because we are right in the center between North America and South America and Central America. So basically, you can use the Dominican Republic as a hub, especially if you are in a three zone regime, so that you can, for example, benefit from a lot of incentives that the free trade zone regime has, and you have multiple options also to ship abroad whatever you produce, textiles, manufacturing of clothes, of medicine, and everything that Alberto talked about. And that is very important. Actually, our firm has been recognized last year and this year again as the #1 firm assisting foreign investors in incorporating free trade zone companies into the Dominican Republic. And right now, we are one of the main economies that United States, Asia, we have even been receiving a lot of Canadian and Indian investment in the last 2 years as well, that want to invest in distribution centers, in logistics centers, that want to have a free trade zone so that they can supply services to the American customers they have, especially, for example, for call centers. We are receiving a lot of requests for pharmaceuticals or companies that are in the business of telecommunications for medicine, for example, for billing or assisting insurance company, that we know that you have in India a lot of companies that offer those services, and they are coming here basically for two things. First of all, we have a lot of people who are seeking employment. Our salaries are lower than in other Latin American countries, so you benefit from that. And also, there is a big community in the Dominican Republic that speaks very fluent English, so you benefit from that as well when you need to accommodate your customers that are in Europe, that are in Asia, that are in the United States. And especially, for example, from India that we have received recent requests right now, one of the concerns they had, and one of the advantages they were seeking in the Dominican Republic, is that they needed to operate a medicine business, and they had this huge disparity in the time zone. So they said, like, our people are working in midnight shifts, 3 a.m., 4 a.m., to be able to assist customers in the United States. So since we have the same time zone, we are in the same time zone, sometimes maybe 2-3 hours only change, we are in the perfect location for you to offer those services as well. So definitely, we are in a very good moment right now in the Dominican Republic to receive investment, and the numbers are there, the statistics are there. We are growing exponentially, and we are receiving most foreign investment than ever before. Even in the pandemic, when a lot of countries were in recession, we never stopped producing. We never stopped receiving investment. Actually, in the pandemic, there was a boom in real estate. People were buying a lot of real estate. A lot of new developments in the Dominican Republic, in all the coast are arising, and we have, for example, we have a lot of Indian companies that have been supplying services for construction, for energy projects, and for other projects, even in the public sector, through national bidding, and even public and private alliances. So we have been seeing this trend from Indian investors that is growing with time, to invest in the Dominican Republic and look for alliances. And we are also here to help you with that. We do that for our clients as well, to put you in contact with the main people, with the main suppliers that are in the market, so that you can benefit from our network as well. So that is a very good thing to do. In relation to residences, many foreigners that want to live or invest in the Dominican Republic are looking into residencies, because there are a few benefits that you can receive from that. First of all, you can work and do business legally in the Dominican Republic. A non-resident cannot. A resident is allowed to, if you are moving to the Dominican Republic, a resident is allowed to bring tax-free their household appliances, kitchen appliances, furniture, and not residents must pay taxes and duties to do that. Many foreigners are interested in not paying taxes in their home, because their home countries do not have a good tax framework, and that doesn't work for them. And usually that requires that you obtain citizenship in another state. So a lot of people are also doing that here, obtaining citizenship in the Dominican Republic to benefit from our tax framework. Residents also can enter the Dominican Republic without having to buy a tourist card. There are 13 significant tax exemptions in certain categories that you can benefit from as well if you become a resident. And you can also obtain driver's license and all other permits that you need to live freely here in the Dominican Republic, that you do not have any prohibition for being a foreigner. Once you get your residency, you can basically live here just as a Dominican will. We have different types of residency. We have the retiree, that basically the main requirement is that if you are receiving at least $1,500 from a pension, either from the government institution or a private company, you can apply for that one. If you are a renters, because you're receiving at least $2,000 monthly, or could provide this income for the last 5 years from a stock market investment, you have property abroad that you're renting, or any other investment that is not salary based, then you can apply for that type of residency. We have also the investor's residency, that once you invest more than $200,000 in a Dominican corporation, a touristic project, a free zone. You buy even real estate, even with tax exemptions such as Comfortur, that basically allows you to pay to acquire in a property in a touristic project benefiting from tax exemptions. Even then, you can also get your residency. And then we have, of course, the family reunions residency when you have an Indian or for any other foreigner working here and they desire to bring their family with them to live here. It's also to say, not because I'm Dominican and I live here, but this country is beautiful. We have a lot of beaches that are wonderful, and we have everything you can desire for beaches, the mountains, the peace of the river. So whatever you're looking for, you can find in the Dominican Republic, and that's why in our slogan for many years, promoting the investment and tourism into Dominican Republic, it has been Dominican Republic has it all, and it's because we really have it all in that term. So that's because that's why a lot of investors and a lot of foreigners are retiring here in Dominican Republic and are buying property even to escape from the winter. Sometimes they come here and buy a property and they say, okay, I'm going there in winter and I'm gonna live in the Dominican Republic part-time. So it's a really good moment for the Dominican Republic, and whatever you need, we are here to help. I don't know if you have any other questions. I think I have talked. I have oversold the Dominican Republic.
Thank you so much for that. That was very enlightening. And I must say there are a lot of similarities to India from what you just said. Our economy is also similarly doing very well. We also have everything. Our slogan for India is incredible India. So like you say, you have it all. Our slogan is incredible India. But yeah, I think I just have one question in terms of, what Alberto had mentioned was French laws, that, you have a French legal history, just the way in India we have the English common law because of our English history.
Yeah.
Does that create problems at times? I mean, in terms of the courts and other legal documents, is it in English? Is it in French? Or, I also did note that tourists from India who need to visit Dominican Republic do not need a visa. There's a visa on arrival, provided you've got an American, Canadian, UK or Schengen visa. So that was quite interesting. And the embassy in India is very close to where we're sitting. It's in Vasant Vihar. So over to you. I don't know whether Alberto, you want to take that, or Pamela, over to you.
It's not a problem at all. Like, it's just history. Like, we put our civil codes in Spanish. Our legal our official language is Spanish, so you don't need French at all. Like, we study French to take advantage of the French publishings and go there and study if you want. Mostly if you're aiming yourself to be a civil law commercial attorney. Otherwise, you don't necessarily have to go to France. But no, it's not a problem at all. Actually, it's even better because we have used the solid precedents of the court of France to establish distinctions over the legal figures that we use in the Dominican Republic. It actually raise our standards on the law application.
Yeah, and in addition to what Alberto just mentioned, basically French law it was our initiation in the law, but over the time we still have a very old civil code that is was based in the Napoleonic civil code. But most of our new laws, for example, intellectual property law, our investment law, our insolvency law, they are all based on international standards. So you will see that they are very similar to what to these model laws that has been used by the UN, that has been used in the, and we have a mixtures there with Spanish law, with United States law. So even when we are not a common law country, because we do not take precedent as our law, but instead we have written law, and then we have the courts and the judges that they make their own opinion and decisions and don't have to abide by the existing precedent. We even then we have a lot of presence of the common law culture in the Dominican Republic in terms of our law, and how modern it is, and how it is adapting to the new technologies, to the new globalization issues. So that is not a problem at all. And here in Dominican Republic, we talk a lot of English, and even when, of course, the national language is Spanish, and everything is presented to the court and to other institutions in Spanish, we usually, for example, we are accustomed to use documents that are half by column, one in Spanish, one in English, and that is not a problem at all. And that facilitates things with investors when, for example, we are making M&As and they want to understand exactly what is on their contracts. We usually do it like that. So rather to being a problem, I think we have a very solid system based on French law. And as Alberto mentioned, we benefit a lot from comparative law. We are always seeking what are the precedents, what are other jurisdictions doing in certain matters, and we take it, and the courts take it as a reference to make the decisions, and we as attorneys also take those precedents in our when we are making our statements for the court. So that is very good. Even in arbitration, that's why we are also taken into consideration when there is arbitration involving the Dominican Republic and other matters. And also, it has become a culture that, for example, we usually go abroad to make our masters. For example, in our office, just as an example, we have people that have Alberto made his master of law in France. I made my master of law in England. Fabio, one of my other partners, made his master of law in Spain. Another one made it in the US. So by having all of those precedents and all of that cultural information, we are able to manage the expectations of the client depending from where they come from, and we try to abide to international standards. So that is not a problem at all.
Thank you so much. I mean, that just reminds me, how exciting this session has been so far. What Leonardo da Vinci once said, that learning never exhausts the mind. With that, I'm going to switch gears and shift to the next topic, which is Indian tax in the age of free exchange of information. And I'm going to invite our next speaker, Sumit Singh, to give his thoughts on Indian tax in the age of free exchange of information. And I'd like to just inform the audience here that India and Dominican Republic do not have a double taxation avoidance agreement. Neither do we have an automatic exchange of information agreement. So, which is, quite unique in today's day and age, where, exchange of information and treaties are kind of becoming the norm. But with that, over to Sumit ji to give your thoughts on the Indian context. Obviously, there is a lot of litigation and sharing of information and free access, to information in today's day and age. How do you think that has affected Indian law, and especially in the context of international businesses and M&As? Over to you, Sumit ji.
Thanks, Raghuji. So as you just pointed out, that India and Dominic does not have a double taxation avoidance agreement, so which is kind of bit surprise. So, And though they have a couple of double taxation avoidance agreement to our understanding, which is with one with Canada and another with the Spain. But having said that, shifting focus to the Indian tax scenario, and if there is actually what happens that in India, this Indian tax authority has been evolving a lot in terms of gathering the information of the overseas structure or the overseas investment or the overseas asset which is being held maybe by the Indian companies or by the Indian resident or someone who is residing abroad and have become a non-resident from Indian tax perspective, but he holds an Indian citizenship or as the case may be. So all this information which is being retrieved is on the basis of the double taxation avoidance agreement which India have entered with various countries. And there is a specific clause which is termed as exchange of information clause, which forms part of the tax treaty. And under that, and coupled with the power granted under the Income Tax Act, the Indian Tax Authority have been quite proactive in terms of obtaining a lot of information about the Indian entities or the Indian resident or non-resident as the case may be. And in fact, they have just Indian tax investigation authorities have a separate cell now, which is typically termed as foreign asset investigation unit, which we typically called FAIU. And pursuant to that, we have observed a lot of notices coming to overseas investor, even for the Indian companies, in terms of their interest and to what extent this interest has been disclosed and to what extent the realization of the interest or the yields of the interest has been offered to tax at India level. And of course, we have seen over the period of time a lot of litigation happening, specifically owing to this Black Money Act being introduced and it is at India level, it is at a very beginning stage, and it is subject to a lot of interpretation, and a lot of matters are pending before Indian courts on various legal principles to what extent and how Indian tax authority really can impose the taxes on the black money or an alleged black money, in the sense that asset or an income which is being held abroad, but the same has not been disclosed in the Indian tax returns. So if we just put it in the Indian Dominic tax scenario, so even though we are just mentioning, we are not intend to mention anything which is not beyond the corners of the law, because being as a professional firm, we always maintain that integrity and we remain within the four corners of the law. But having said that, any company or any resident of Dominican Republic, so due to lack of exchange of information, so tax authority may not be able to obtain much of the information about the assets and investment. This we are saying from the perspective that what a lot of times happens, that the tax authority may have a bit of information and they want to inquire into, and even needing to inquire into and putting a lot of time and effort in putting responses to the inquiry raised by the tax authority gets a lot of means it ends up consuming time, and of course the consultants do get involved. But if there is an India Dominic scenario, so of course Indian tax authority may not have much of the greater detail of information. However, and they may have to the extent they are able to obtain from their whatever sources, and in fact utilizing any information which they have apart from the information coming from the competent authority is not termed as a relevant information from Indian tax context also. So from that perspective, one can correlate with the Dominic and India Dominic tax scenario. Whereas to our understanding that the corporates are paying in Dominic are paying a tax rate of 27% as compared to Indian tax rate, which I'll say is slightly better. In the sense that manufacturing companies complying with certain conditions are subject to only 15% tax, and other than manufacturing companies, the rates have been reduced considerably to 20%. And this is where there's a bit of a difference. But one key aspect is that in case of, I think in Dominican Republic, any income earned outside the Dominican Republic is not subject to tax in Dominic. Whereas as compared to Indian tax law, which is on the residency tax scenario, in which any Indian resident, his global income is taxable in India. Maybe someone who is an Indian resident, an individual who is earning income, suppose from Dominican Republic also, and there is no double taxation avoidance agreement at the same time. And since he is an Indian resident, he might be offering his global income to tax, which includes Dominican Republic income. And due to lack of treaty, there may be a bit of complication in terms of ability to claim the tax credit at India level. But however, yes, on the other side, to our understanding, there are relaxed provision from the Dominic side also, because any individual can become a resident as through an investment of about $200,000 in an investment project or any other manner. So once a person becomes a resident individual of Dominican Republic, then he may be subject to Dominican Republic tax rate, which is to our understanding is ranging from 10 to 25%, depending upon the slab of income in which that or the bracket of income in which that particular individual is falling. Except for the financial resource earnings, which to our understanding is taxable, except the case where an individual is gaining a residency based upon the investment of $200,000 number. And as another opportunities which Dominic can offer, which is similar to Indian tax law, which earlier Indian tax law used to have that SEZ tax benefit, which used to be for 15 years. Now, due to reduction in the tax rates, there is a sunset clause on this particular law. However, any Indian entity who may want to take a benefit of Dominic free trade zone, as touched upon by Mr. Alberto, wherein I think there is a around 15-year tax benefit available those who are operating a free zone, apart from the no custom tax or there is no GST tax, etc. So this is where one may try to reap in the benefit. So with this,
Thank you so much, Sumitji, for explaining to the audience about the pros and the cons of not having a double taxation avoidance agreement. Because although our Indian Income Tax Act does cover under Section 91, the double tax avoidance, but like you correctly said, corroboration of data, obtaining data may be a little cumbersome for the tax authorities in the absence of a treaty and an exchange provision. With that, we're going to shift gears to Jagrati ma'am, who is our next speaker, and topic number 3, which is on cross-border M&A in India. And as Mr. Marwa gave in the introduction, Jagrati is going to touch upon the NCLT, which is our National Company Law Tribunal, as well as the Reserve Bank of India, which is our exchange regulator. And with that, I'm going to pass on to you, Jagrati, to share your thoughts on cross-border M&A in India and the relevant guidelines of NCLT and RBI in this regard. Over to you.
Thank you, Raghu. Good morning and good evening, everyone who is attending this webinar. I will just quickly touch upon the growth of M&A activities in India. In the realm of global business environment, M&A has emerged as a very powerful tool for the companies to expand their reach, enhance their competitive edge, and unlock their growth opportunities. I would agree that India is a burgeoning economy with a vast consumer base, strategic location, and has become increasingly attractive destination for cross-border M&A activities with an objective either for market expansion or for cost reduction or for technology transfer, diversification, strategic alliances, more so over to reduce the competition. M&A market in India in 2022 was worth USD 160 billion, out of which around 50 billion USD transactions were pertaining to cross-border M&A activities. There are two types of cross-border M&A which is happening. Inbound merger, which is where the foreign company comes into India, and outbound merger, wherein Indian company is either acquired or merges with the entity outside India. Now let me bring to the history or evaluation of the cross-border transactions in India. Erstwhile, Companies Act 1956 had no provision with respect to outbound merger transactions, but the Companies Act 2013 introduced Section 234, which permitted inbound as well as outbound merger of the companies situated in India and outside India with the permission from RBI. So it's still section was talking about the permission from RBI. So RBI came up with foreign exchange management cross-border merger regulation in 2018, in March 2018, wherein it has provided a set guidelines that if you comply with the certain conditions which are mentioned in this regulation, there is no need for RBI permission, and it is considered to be a deemed approval from Reserve Bank of India, which is the Central Bank of India. With this amendment, as I mentioned earlier, there is a surge of cross-border mergers and acquisition transactions. A very well-known outbound merger example is Walmart acquiring Flipkart, acquisition of SB Energy by Adani Green Energy, which is for 3.5 USD billion, Axis Bank, which acquired Citicorp Finance for 1.6 USD. Similarly, there were transactions for inbound mergers where Oman Tanvir's Infrastructure's acquisition for Indian coal business, Shell's acquisition for Solengiri, Proximus Group, which acquired a Route Mobile with an estimated value of USD 1 million. Now, let me touch upon in short for RBI requirement with respect to what is the deemed compliance. There are two parts to this. One is inbound merger, wherein foreign entity is coming into India, what you need to do, very useful regulation for this. So I would like to touch upon a little bit on that. Because the Indian company will issue shares to the shareholders of the foreign transferor company that needs to comply with foreign direct investment guidelines. You are allowed to operate the foreign bank account for the period of 2 years from the date when your merger scheme is approved by the National Company Law Tribunal, which is similar to High Court. Your foreign entity, which has been acquired by an Indian company, that will be considered as a branch office of an Indian entity outside India. If that foreign entity has any borrowings which has been taken in an external and that has to comply with external commercial borrowing guidelines, and you should not repay that liability for the period of 2 years. Similarly, for outbound merger, as the shareholders of the Indian entity will receive some consideration from the entity, foreign entity, that should comply with foreign overseas investment rules. And if they are individuals who are getting the consideration, they should comply with liberalized remittance scheme of India, which has certain limits of 250,000 USD, within which range you can freely acquire this assets. A branch of this Indian entity will be considered as a branch office and a permanent establishment of that foreign acquiring entity. If Indian entity has any borrowings, that needs to comply and it needs to be repaid as per the scheme sanctioned by National Company Law Tribunal. The resultant company for the bank account may open any special non-resident rupee account or external foreign exchange management deposit regulations according to these regulations. For the assets which are held by both either the Indian company or by the foreign company which is under the acquisition, these assets which are not permitted to be held under the laws of the countries, they needs to be disposed of within the period of 2 years from the date of sanction of the scheme. As there are too many compliances which require to be done, you need to submit a certificate from the managing director or a whole-time director coupled with the company secretary if he or she is required to be appointed by the company to the National Company Law Tribunal that you will comply with all the rules and regulations. Now, let me come to some of the important provisions of the Companies Act and National Company Law Tribunal rules. One of the most important requirement of National Company Law, Companies Act 2013 is with respect to jurisdiction test. Now, the companies which are within a particular jurisdiction, they are only allowed to have the outbound mergers in India. Dominican Republic has entered into it has a participation in an international community. There's a membership with the World Trade Organization. It has other ties up with the Central Bank and Financial Action Task Force. It is also a signatory to the bilateral memorandum of understanding with the SEBI, that is Securities and Exchange Board of India, and therefore all the companies from the Dominican Republic are allowed to enter into an outbound merger transactions in India. There is no such requirement with respect to inbound mergers. However, it is advisable that you should have this jurisdictional test, as in case of the scheme of merger of OSS Chartering Private Limited, which was a UAE company, which merged into CY Chartering Holdings Private Limited, which is an Indian company. Kolkata NCLT has specifically stated that you should test, even this jurisdiction test has to be done for inbound transactions. Let me take you through a little bit of NCLT process. It's not very stringent, but yes, it is a legal compliance under the Indian laws, wherein you have to draft a scheme of amalgamation once you enter into a merger agreement. Okay, and this scheme of amalgamation should encompass within itself a requirement of valuation. This valuation of both the entities or number of entities involved needs to comply with international valuation standards. Basis this valuation, you need to decide on the consideration, and that consideration can be in the form of issue of shares or depository receipts or cash or part of each of them. This consideration and valuation needs to be a part of scheme of amalgamation. Along with scheme of amalgamation, make an application with supporting the application with authority of board resolution, then the financials of all the companies involved, the charter documents, the list of shareholders or the owners, and a list of creditors. If you can produce the consent letter of creditors, that will be an additional support, and you did not have any meetings either of the creditors or of the stakeholders. Once you give all this information, National Company Law Tribunal itself seeks the approval from the Registrar of Companies, Regional Director, which is a central body, as well as official liquidator if there is an outbound investment. All these agencies will give their report, and NCLT, if it is satisfied with all the information given, this scheme is approved. Once the scheme is approved, the matter is resolved, and you can move ahead with issue of consideration and do the businesses. This is how the scheme at RBI and NCLT has been formalized in India, and it has some income tax provisions, which is, beneficial to inbound as well as outbound investment, except that the tax rates for the companies in India will turn out to be 40% if there is an outbound merger. I hope I have clarified the position here, and if you have any questions, please let me know. Thank you so much.
Thank you, Jagrati ma'am, for a wonderful exposition on cross-border M&A. With that, I'd like to give an opportunity in case there are any questions or if there are any doubts. I had seen earlier, I think one of the delegates had raised their hand, but I see it's now put down. Any questions, Pamela, that you may have, or I see George as well on India business, on what Sumit and Jagrati said?
No, I think it's very clear. We of course would like to receive supporting material if you have it, so we can have that in for potential clients that would like to invest in India as well. That will be very, very good if we can receive that.
Absolutely. So with that, I'd like to conclude by quoting Arnold Schwarzenegger, who had said that strength does not come from winning. Your struggles develop your strength. When you go through hardships and decide not to surrender, that is strength. So I hope you all will have the strength to develop India as well as Dominican Republic trade and business. And with that, I'd like to thank you all for your kind participation and for your presence, and say goodbye and thank you very much to the panel.